are live and recording on YouTube.
Yeah, what's most important is the recording, obviously. So excellent. Dimitri Downing here, founder of Meta. This is exciting stuff. Schedule 3. Maybe it's exciting stuff. We're going to find out. But first of all, I want to introduce our guests today and thank them all for coming. I'm looking at the screen, and the billable hour here is probably like $2,500 of time for the. I don't know exactly your guys' exact billable rates, but I was thinking about that. So everybody out there who's watching this should greatly appreciate your guys' time and your information. And I'll start with our host today. Lou, you want to introduce yourself and to the community?
Dimitri, I thank you. I'm Lou Magazoo. I am an attorney in New Jersey. I have 15-year county commissioner, 15-year municipal attorney. Before getting into cannabis, I was a development attorney in cellular, malls, assisted living facility, cable TV. 2018 had my first opportunity to represent someone in a company in New Jersey it was then medical. We did well. And since then, about 30 applications, I think, at this point. I handle the land use. I work with the experts with respect to the CRC application, and enjoyed very much the opportunity to work with my friend Dimitri and this august group of great minds and scholars. So I look forward to the opportunity to talk about something that is very serious, lots of implications, and at least from my perspective, more questions and answers.
John, do you want to go ahead and introduce yourself?
Yeah, I'd be happy to. Thank you, Dimitri. My name's John Udell. I'm an attorney, a lobbyist, and medical marijuana patient out here in Arizona. I've been practicing representing marijuana clients going back to the medical days before adult use legalization in Arizona. Around the time of legalization, I joined the board of directors of Arizona NORML out here and played an active role in advocating for the legalization measure. And since then, I've been representing businesses as well as engaging in continued advocacy at the Capitol to change our laws for the better. So like Lou said, there's some really interesting stuff to discuss today. I think a lot of surprises, a lot of questions that are raised, and really a lot of potential implications, not only for businesses, which we expected, but also for medical marijuana patients. So again, I'm grateful to be here, and I'll toss it back over to you, Dimitri.
Yeah, and Jeff, you want to go ahead and introduce yourself, and follow that by Tom. And Tom, after you introduce yourself, let's go right into the legal foundation. You can talk about what exactly the DOJ did here. I know you have a pretty good summary of that. So Jeff, go ahead.
Sure. My name is Jeffrey Hoffman. I'm a cannabis attorney and legalization activist in New York City. In addition to my practice, I have a little show on LinkedIn called Ask Me Anything About Cannabis Legalization in New York, which we do every Wednesday at 4:20 p.m. New York City time. Really excited to talk about this topic today. It's something I've kind of been talking about a lot, both on my show and with folks all over the city and all over the state, and looking forward to get into the good, the bad, and unfortunately what I think is the ugly of what the federal government has now done here. Over to you, Tom.
Hey, everybody. My name's Tom Howard. You can find me at, probably Cannabis Legalization News on YouTube. I am a lawyer in the middle of Illinois, and then I also have a dispensary that should be open. Well, it's May. It's May 1st. Happy May Day, everybody. This month, and which is just a real boondoggle. This industry is not easy, and then to make it more difficult, they've now bifurcated it. And so my adult use is completely still Schedule 1, even though it's essentially the exact same regulations that an Illinois dispensary has to follow for medical use, with some slight tax and patient discrepancies. But, you know, those regulations are minuscule compared to the pile of regulations that you have to comply with. And then you have, if I buy it from my medical shop with my card, or if I grow it with my medical card, my five plants, that perhaps might be Schedule 3. But if I sell it from my regulated shop, that is not a medical shop, that is Schedule 1, which brings us
just real quickly, the actual document, the actual procedural step as to what happened here with the DOJ and what they did. and what's going to happen next. I just want to talk a little bit about the process and the piece of paper itself.
Piece of paper itself was what they call a final rule. There was not a notice of final rule. There was not a notice of proposed rulemaking. There was nothing. The acting attorney general, and so it's not even an attorney general, Todd Blanche, published a final rule that nobody had expected. And so just like Monty Python's sketch with the Spanish Inquisition, we have the single convention of controlled substances that the UN passed in 1961. Approximately 10 years thereafter, that international law was engrafted into the Controlled Substances Act that was then passed by Congress. Interestingly enough, with a Part F that studied marijuana that became the Schaefer Report, they threw it in the trash, and they, is Nixon administration in that respect. You fast forward 50 years later, and you have another Republican administration completely undoing that, because they could have, in theory, read the Schaefer Commission and then rescheduled it to Schedule 3 to allow for medical cannabis to be the law of the land. They did not do that. So they filed a final rule for medical cannabis to be in compliance with that 1961 UN charter, and it is fascinating, just unexpected. I don't know anybody I've talked to that had that on their bingo card. And we have a very, as Lou mentioned, an august group of attorneys here. Anybody see this one coming? Seriously?
No, Jeff. Okay,
Jeffrey.
and Jeff, and we'll get into the politics and all that kind of stuff. But I just want to make clear exactly what this piece of paper is and what it means and what step it is, procedurally speaking.
This is
Jeff,
a final
go ahead on
rule.
that.
Oh, Jeff, go
No,
ahead.
let Tom go. Tom is rolling. I like what Tom's doing. He's got this nailed.
Yeah,
Go ahead, Tom.
It's a final rule published in the Federal Register. It is law. And
Yeah.
it might be a 30-day. And then, oh my goodness, if you read the whole 30-some pages, they do this, and then they explain that all these other laws don't apply to it. So it's just skipping the line on numerous federal laws. And then, Florida alone is hundreds of millions of dollars, because every Florida license is a medical license. So they're all fine. Missouri, every license is a medical license because they have hybrids. In Illinois, we only have 55 medical dispensaries. And then the portal that they put out is just for medical dispensaries. But the legal act that they made was changing federal law so that now marijuana, the same identical marijuana, so the same SKU that is sold in New York or in Illinois or in New Jersey or in Arizona, that goes to one shop, being the medical shop, will be Schedule 3. But then if that marijuana is shipped over to an adult use shop, that is Schedule 1 right there with if it fell off the back of a truck in Oklahoma somewhere and then ended up in a Texas hemp shop. Fascinating is an understatement of this.
Yeah, we're going to get into the cultivator perspective, the retailer perspective, manufacturer perspective, the patient perspective, all that eventually. I just want to lay out clearly where we are at procedurally and what's going to happen next. People are talking about 60 days this, hearing in June this, Schedule 3 hearing in June, more rules, more executive rules coming down the pipeline. Anybody else want to chime in on that?
Dimitri, to extend the Monty Python analogy, instead of the federal government, the entities that should run this are the knights who say "nee," because there's a different set of rules depending on the section of the law that you read. Am I the only one that's old enough to remember the knights that say "nee"?
Oh,
No, of course
Monty
not,
Python?
sir.
Anyway, but
Eki patang.
you know what? You are the best. You are the best. To Tom's point, and I don't want to get too much into the weeds, no pun intended, but I think it's important to talk about the procedural history, or the absence of the procedural history, and the fact that it came really wholly born through the pen of the acting attorney general. And those procedural steps, which are perceived perhaps as niceties, also have a purpose in terms of a vetting purpose, a determination as to whether going to the left or going to the right or going down the middle, what makes the most sense. And none of that happened. I would suggest, a cynic in me, that if I was prosecuting an unpopular war and I was worried about files coming out, I would find something else to make newsworthy. But maybe that's just a cynic in me. But as a consequence of the lack of procedural appropriateness, not only do I think it's potentially flawed by way of legal challenge, but I think in terms of implementation, it's a disaster. And I suspect that none of this, we will not see the benefit. Maybe we'll see the detriment. And maybe we could talk at some point whether, again, a little bit of my conspiracy theory, whether this is all really ultimately an attempt by the pharmaceutical industry to take something they've coveted for a while. But just as to the main issue here, I have some real questions as to whether procedurally and substantively this is ever going to really hold up because of the way it was born.
Yeah,
Tom, go ahead, John.
Yeah, was gonna jump in there for a second. I think that Lou raises a lot of really salient points there. I've been thinking a lot too about the legal challenge, the extraordinary path. There are a lot of extraordinary things about rescheduling, from the contents of what it does to how it happened. And I think that the circumventing the typical notice and comment rulemaking that usually fleshes out a lot of these issues, I wonder what that does to the long-term viability of this rule. I've seen on social media and news releases, Project SAM, which is of course very active across the United States right now in trying to repeal marijuana reforms, have already announced that they plan to challenge this in court. I wonder too if this looks like if it goes to court, if it ends up being all approved, all struck down, or somewhere in the middle. Maybe rescheduling can survive, but not all of these very unique provisions that provide for the registration of state licensed dispensaries. And also, I thought it was interesting, a little bit of a quick tangent here, circling back to a comment that was made earlier about how the rescheduling actually looks. It's not rescheduling, quote unquote, medical marijuana, but marijuana that is in an FDA approved drug or, quote unquote, subject to a state medical marijuana license. So I wonder too, circling back to Tom's comment about home grow. I mean, when you do home grow as a patient, it's for a medical purpose, but is it subject to a state medical marijuana license? It doesn't really seem to be, unless your patient registration functions as a license for that purpose. And I see Jeff shaking his head. I don't know.
It does in Illinois. Like it's literally a thing in Illinois where if you're
It's
just an
state
adult,
specific.
it's state specific. And so arbitrary and capricious, another legal term that is thrown around quite often. This rule, it's a final rule, it may fit that term of arbitrary and capricious, especially when you consider it's like the exact same SKU and it's on two different trucks. One goes to the medical dispensary, one goes to the adult use dispensary. They are treated differently under the federal law. And
Before
why?
we assume that this is going to stay in place, timelines and potential adversaries, Sam, do they have the resources? Do they have the firepower?
Yeah.
The pharmaceutical companies might challenge this. Different marijuana groups might challenge this for different reasons. What do you guys see on the horizon, date-wise, time-wise, and individuals out there who might rattle the cage?
Oh, okay. I did an X deep dive into Sam's filings. Is Sam's smart approach against marijuana? Whenever you hear that, we're not talking about a person named Sam. We're talking about an NGO that advocates for repealing any type of liberalization of the marijuana laws to keep them criminal. So Sam has to file reports as it is a 501c4, I believe. And as a result, you can't see, it's opaque. You can't really see where the money's coming from, but you can see where the expenses are going. One of the expenses was over $300,000 to Bill Barr's law firm, Torridon Law. And they made $12 million in their most recent filing from 2024. They'll have a new filing, of course, with the new tax year of 2025. One thing that this interesting final rule does is effectively double their litigation budget. And you'd think that our hourly rates would be difficult to pay. Torridon Law is a boutique law firm, and he is the former Attorney General of the United States. So I'm assuming he is north of $1,000 an hour. The associates that work on it are north of $500 an hour, and a $300,000 retainer is going to get ripped real quick. And so, hopefully Sam can write more checks to Torridon Law, because now they're going to have to do it twice. As this is a final rule, it's what they call like a final administrative decision that typically kicks off a deadline, of a short deadline in which to file an appeal. I'm not exactly sure what it is at the federal level, but probably 30 days. So you will see a lawsuit filed before May is out. And what will they be alleging in the lawsuit? Well, probably ultra vires. They went beyond the power granted to the administrative branch, and they've really encroached as to the powers that are supposed to be reserved to Congress. That may be effective, but we'll see.
Jeff, John, on a certain level, it must be satisfying to see the prohibitionists on the defensive, though.
Yeah, I mean, 100%. And I love that this is a victory for common sense. I think victory for common sense, potentially a victory for market fairness. And I also, in terms of heads exploding, I'll point out a tweet. I think it was from Kevin Sabet, who's the director over at Project Sam, complaining about how I think it was podcast hosts with an active addiction are making drug policy for the organization, for the administration. So a lot of interesting comments after this. Also interesting comments that I think triggered, fueled some of this backlash from Project Sam even more. I caught one comment in the final rule, just remarkable to hear from the federal government comparing marijuana withdrawal to alcohol withdrawal, and saying alcohol withdrawal is a lot worse and it can even lead to death. And just fascinating to again see a document from the United States government that seems to suggest that marijuana is safer than alcohol.
If you don't mind, I would like to jump back and talk a little bit about the exact history of how we got here in the near term.
Absolutely.
Let's not forget the previous president of the United States, Mr. Joe Biden, did exactly what Trump did. He issued an executive order ordering the people that work for him, in theory, the Justice Department, to go through this process, to do some kind of rescheduling process. It's usually the right in this country and people that like right issues that complain about the quote unquote deep state. This was a turnabout as fair play and an issue that the left in this country, cannabis legalization or some type of movement on that, got impacted by the deep state. Basically, for the remainder of Joe Biden's term, the people that work for him just said, yeah, it's great. Go back to bed. We don't really care about any of this, and have a nice day. President Trump gets reelected. Obviously, we were 45 and 47 there, so it's not technically reelected, but elected again. Dimitri, you and I talked about this sometimes when we met. I got a lot more vocal about it when Trump got reelected and just said, look, Trump is a Republican in name only. His real political party is the Trump party. And I thought at that point was the most likely time in the 50 years since we had the Controlled Substances Act or anything about cannabis in this country that something would happen. We all also know that, and I hear the ideas of, oh, there's certain files that we don't want the press getting out about, all these types of things. I just think it's fascinating that an issue that I think if you'd have asked anybody that really knows anything about it, which party is going to be the party that moves on this, folks it would have been 100-0 that it would eventually be the Democratic Party and their legislators or executives that have done this. It's fascinating that it's come to be Trump. Again, the reason I thought it was most likely to happen is Trump doesn't play by the rules that everyone else seems to think they have to play by, right? Trump is running this country by executive order, like it or lump it, right? I mean, and he leaves it to the Supreme Court to clean up his messes in a lot of cases along these lines. And I thought there was no question that at some point Trump would reissue the executive order that Biden already issued. He did. Trump then got deep stated. I mean, remember, he issued this order 5-6 months ago, and basically nothing happened, right? And then Joe Rogan and a bunch of other folks are up there at the White House. I think they were signing something about Ibogaine and the psychedelic things, an executive order of that line. And Trump basically, as he does, goes off the record and says, they're slow rolling me on cannabis, Joe. They're slow rolling me. I mean, literally, that's the quote. That's what he said to Joe Rogan there in the White House. And so we all know he fired Pam Bondi, who was his attorney general that ultimately was responsible for being in slow roll. If Pam Bondi had gone to her people and said, Trump said, do this, do it immediately, it would have happened back in December or whatever. Trump fires her, has his former personal attorney in the position now. And what do you think is going to happen when the president on the news says, they're slow rolling me, Joe? My people just need to get this done. Todd Blanche said, I hear you, sir. And me, like literally a day or two later, what do we get? This order from the acting attorney general that we've all questioned the procedural natures to it and the procedural bona fides for it. But again, we're dealing with an administration that just really doesn't care about that for good or bad. And so they just went ahead and basically legalized medical cannabis via executive order. That, in a nutshell, that is kind of what has happened here. So I did kind of want to talk a little bit about it procedurally, because I just think the dynamics of this blow my head up, blow everybody. Again, the party that it came from, and again, Trump isn't really a Republican. We've talked, but just like where this came from, how it happened so quickly procedurally, really upended the vote. And I think everybody's at a loss for what happens now. I mean, obviously, we know we're going to have hearings this summer, but like, I think everyone is now scrambling because of kind of the let's just blow it up nature of how this administration operates.
And
Yes,
Lou,
I
I want to hear from you on this subject, on what we're talking about right now. But then we're going to get into a little bit about how this might impact manufacturers, cultivators, businesses, and what they might plan for. But obviously, the history and status is extraordinarily important. So, Lou, go ahead.
Well, Dimitri, you may remember that about a year ago, I actually suggested to you that I thought the best way to get to either rescheduling or something akin to that was Donald Trump as president and a Democratic Congress. And that analysis was because now I happen to be the only person on this group that actually sued Donald Trump when he was a casino operator, successfully, by the way, settled about 75 cents on the dollar. And I got to know him a little bit, not well, but well enough that I had dinner with him once. And he is extraordinary. As we all know, extraordinarily transactional. And he also wants to make a difference, good, bad, or indifferent. He wants to make a difference. The Republican Congress would never, ever go for this as a piece of legislation because of the far right. Democratic Congress, I think, is more likely to do so. Now, why am I saying all of this? Because if, in fact, the Democrats win the House and the Senate, and the procedural deficiencies and substantive deficiencies that we've alluded to become clear, there will be an opportunity to clean the mess up. And that is to actually go through the right procedures legislatively or through the regulatory path. But there may be a way, and call me an optimist, not often, but in this instance, perhaps, that I think with a Democratic Congress, there may be an opportunity to, and Trump as president, to get to something that really approximates where they wanted to go, assuming that they really wanted to get to a place where there would be, for lack of a better term, legalization of adult use. Now, Tom's points about the fact that there are virtually innumerable flaws with respect to the way they treat adult use and medical use, and the fact they're treating the same plant in two completely different ways. And maybe that's because that's how it developed in the States originally. But, you know, it is yet another issue. But I would be reluctant to tell anybody to make any kind of plan based on what came from Washington, because I think it's so flawed that the money you're going to spend, the first money spent on this is going to be bad money, because I think there's so much uncertainty. And a reasonable court, I think, is going to send it all back and say that there's just too many. I don't think they'll be able to bifurcate and take the good out from the bad. I think they're going to say the process was so bad and so inconsistent with their protocols as to throw the whole thing out. And that's my prediction that ultimately will happen once it works its way through the courts.
And that's interesting. And I want to talk, because I see a lot of Schedule III opportunities. I see a lot of business opportunities that, if things remain in place, could occur. And smart businessmen wait. They don't necessarily want to be first. When do you see this settling down, time-wise, procedure? There's that big hearing at the end of June. How long should somebody wait before they, keep in close contact with your attorney, and be patient? But how patient? How long? Because everybody wants to be the first actor, etc. Timeline, time frame. What do you guys see? Lawsuits, process, hearings.
Lawsuits very quick. And so like lawsuits within the first 30 days. But then I don't know how long that lawsuit will last. Like the lawsuit will probably ask for injunctive relief. So like the lawsuit will probably say like I need a PI or a preliminary injunction and a TRO, a temporary restraining order, enjoining the United States from enforcing this. And so while we have, because like this week the 60-day portal opened, and so like all these medical cannabis licenses can fill this out right now. And so while that process is going on, the lawsuit will be filed in the next 60 days. And then they will ask for everything to stop. There's a one going on right now in Texas, an injunction that happened in Texas for something that became effective approximately a month ago. They changed the rules for hemp flower. And you might see very similar arguments made, like, well, this ultra vires, like you're encroaching as to like this was Congress to decide this. You for 50 years haven't said that we should enforce the single convention this way. This is extremely novel reading of it. Shouldn't Congress have been involved? And also, why do you say this isn't a major rule that's $200 million or more? This is clearly worth billions of dollars a year, and you just go to it being enforceable while you're dual tracking, and you're going to they canceled the hearing, which great, and now they're going to restart the hearing in June. Now that's for the full section of the rescheduling for all of this marijuana under a different section of the Controlled Substances Act. Same provision, 811, but the one regarding compliance with our international treaty obligations is 811D, and the one regarding the change by the Attorney General to a different, the one that Joe Biden kicked off 3.5 years ago now is 811A. And so that's why they have to have that hearing on the, so that they can have the change be there, and it would be more bulletproof if and when the SAM files that second challenge to the administrative process that's happened. This first challenge probably going to be successful. That second challenge, after they let that whole thing play out, probably won't be successful.
Let me just throw out a hypothetical. If I'm a dispensary owner who looks at this and suddenly says 280E, I'm getting retroactively millions and millions of dollars, and I want to jump in and participate in that lawsuit that somebody's trying to stop this new law. Isn't that something that a lawyer could handle and do? Or wouldn't that be a good idea to do that? Given that you have momentum?
Anyone want to jump on that one?
I don't see
IRS
it.
doesn't like doing things retroactively.
Look at the recent tariff findings, where there was a determination that the tariffs were illegal. Nobody's going to get, none of us who paid extra tariffs are going to get our money back. Okay, it's going to go somewhere else. So, and I same analogy. I don't think there's going to be any clawback or retroactive activity with respect to 280E.
And regarding the tariffs too, it's an interesting topic. I've been thinking about this analogy potentially 280E and the tariff refunds. And there's another difference, I think, between these on top of that, which is that the court with respect to tariffs found those tariffs were unlawful previously when they were applied, whereas versus here, there's no finding that we were wrong before and it was unlawful to leave it in Schedule 1, just that they're changing the schedule. So I don't know. I'm not 100% sure about standing in a case like that regarding jumping into the debate. I haven't given a ton of thought to that issue, but regarding the overall topic of what's the timeline like, how long should people wait? I think like many of the issues that we'll be discussing today and have discussed thus far, a lot of these are going to depend. It's going to vary from person to some degree, I think, depending on what your personal risk looks like. For example, that question could look different for a medical-only medical marijuana place in Florida versus a dual licensee out here in Arizona. If there is a world where dual licensees are able to apply and get registered right now, and again, Trulieve just submitted 200, I think, applications I saw yesterday, which presumably I think includes some of the dual ones here in Arizona, and they've been reported at least to have ties to the Trump administration. So, but again, that's different than a dual licensee out here, where compliance could potentially cause the segregation of product and a lot of other operational changes to meet DEA regulations for registrants. So it likely varies, I would say, from one business to another, and it's something that y'all should be discussing with your attorneys.
So before we get into all those potential business models, plans, strategies, which there are lots of, and if this everything remains in place and there's no challenges, et cetera, this 60-day thing, obviously Trulieve is participating, and lots of people have talked about this DEA 60-day thing. Could you expand more? Who wants to expand more on that and what that is? And it seems like everybody's running through their attorneys to get this done.
Well, the form is really easy. And so like it's the 60 days was in his order, and by his, Todd Blanche's order, saying that they are going to fast track the medical marijuana license holders throughout the states that filed their registration in the next 60 days and process them within 6 months. So in theory, they would be the first ones to the door of IRC 280E not applying. Now, oh my gosh, this 33 pages that he wrote was just like a gift of like, what the heck is that? And so during it, he like is giving an advisory opinion, which of course he's a lawyer, even though he is the chief prosecutor of the United States, he is still not competent to give a legal opinion. That's why we have judges. And so he is giving like an advisory opinion to Treasury to retroactively apply 280E and like directing the Treasury to issue guidance as to that, which Treasury has issued guidance regarding the cannabis industry previously in 2014. The FinCEN, I believe FinCEN's in Treasury, but it is a federal criminal enforcement network for like cash. And so that's one of the things that you have to comply with is this guidance from 2014 regarding banking in the cannabis industry. And so like in theory, the IRS could issue guidance that they will not be enforcing IRC 280E since 2023. That hasn't happened yet. That would be like another just like, wow, that's fascinating. The IRS has done this. But FDA issued guidance that they aren't going to be enforcing the law regarding putting CBD and THC into foodstuffs, provided that, and then it has to comply with aspects of it, because this is for Dr. Oz's and Howard Kessler from the Commonwealth Project's, pet project of having full spectrum CBD oil available for seniors and cancer patients.
So would people be any medical marijuana license holder, would you advise them to go ahead and push forward with registering just like Trulieve did? I mean, I guess maybe I should be careful about saying advise because you guys are all attorneys and you want to be careful about that. But how do you want to phrase that? Is that a good idea? If Trulieve did it.
Again, there's fascinating aspects of it. And so like part of it is you have to violate your Fifth Amendment rights. One of the things that you must check is whether or not anybody involved has been dealing controlled substances, which Trulieve has been dealing controlled substances for years. Many of the clients that you would advise out there throughout the United States, there's like 8,000 medical cannabis dispensaries that are throughout the United States. Only about half of them are adult use. And so like, trying to advise them as to that, you could explain like the trade-offs and say they can make the business judgment, but it's $794 to apply. And then if you're going to ask the IRS for like a refund, if you are going to say like, hey, retroactively, I want to amend all my 3 years of filings, and you hire like Calyx CPA to do it for you. Trulieve, I believe, has already gotten a huge refund from the IRS, like hundreds of millions of dollars. So
I think they're also holding back paying. So, but go ahead.
And holding back paying. And so like they have enormous incentive to paper their file with legal compliance to the best they can. Okay. But that's not advice. That's just think of it from a business perspective. Here's the pluses, here's the negatives. It's your call, client.
Right. And it's a major concern because as an attorney, you can't advise your client to admit to violating federal law on a federal document.
Right, but then that federal document is asking you to violate your Fifth Amendment rights. And so like you're that is a rock and a hard place. That's a Faustian bargain. And so you could apprise them of what the federal law is telling them to do. The absurd conclusion is then for them to make.
Yeah, I think the thing we can all agree on is that we would certainly not advise our clients to lie on documents that they are filling out that they're going to submit to the federal government. I think we can all agree on that.
100%.
But you would be advising them to admit that they're currently in violation of federal law. I mean, if you advise
no, I didn't say that at all. I said I would not encourage them to lie on documents that they're going to submit to the federal government. Whether or not you're going to submit those documents is a whole other question. Things that we can all agree on.
And to highlight Tom's point quickly too, it's not telling people what to do, but advising them of the risks and the benefits of their different choices that are at their disposal, and then letting them make the business decision.
Correct.
So each of you will undoubtedly be sitting down with a number of operators from a number of different states, Illinois, New York, New Jersey, Arizona, and discussing this. So, I mean, these are very complicated times, but I see tremendous business opportunities in place for medical marijuana in regards to potentially interstate commerce or international commerce if this remains in place. Are any of you guys optimistic enough that this will remain in place to talk about that?
When you say this, do you mean rescheduling or this rescheduling?
This piece of paper.
It's a really important distinction, Dimitri. I mean, it's a really, really important distinction.
This
shiny object is not nearly as attractive.
Feeling,
as some people
you guys
would think.
know all sorts of producers of different brands of medical and adult use cannabis in all sorts of different states. They're looking to go interstate. They're looking to go international. Retailers are looking to figure this out. I mean, when they first come to you, what's your first thoughts to them? What do you say? Who wants to take that one?
Well, again, we're part of the compliance stack, and so like the possible medical cannabis license holding client, let's say they're in Maine. They could be like, hey, I consulted expert federal attorneys regarding this change before, and then I consulted my taxes and my CPAs prior to filing our amendment, and I made the business decision after that informed. And so we're part of the compliance stack, but we are not we're not bulletproof vests or anything. However, we could then explain to our clients, well, what's the probability that this will go badly for you? And well, what's the probability that you'll be audited, for example? Or what's the probability that the United States will suddenly enforce the federal marijuana laws against your business? Those are both like low probability events if we just go with the actual numbers. But while we help them say that they are acting in good faith and in compliance with what they believe to be the federal laws, we're not magicians, we're not wizards. We're not able to declare that this will be 100% fine, but we do have a role to play. And if there are, I mean, come on, these are medical marijuana license holders. They understand risk. They knew it was illegal. They did it anyway, but they tried to follow their state laws. So I think many of them will think it's a trap. Like, hey, this is a trap. And I think many of them will be like, maybe it's a trap. I'm going to go get my refund. And I want my file in order saying like, hey, I followed what you guys were telling me to do. And you cannot be, I mean, who's lying to who? I'm not allowed to lie to you, or that's a federal crime. But you can mislead me and create traps and do all these types of things. And so, it's a very difficult decision for them to make. But it's fascinating and it's historic that for the first time they get to actually make this type of decision with how to be federally compliant.
And you know,
Yeah,
just an interesting thought. All four of you guys can do the research and see who files these DEA things. Then wouldn't it be kind of like reasonable to like if truly adult use slash medical licenses in Arizona are filing, just follow the lead, kind of do what they're doing.
You mean Lemmings going off the cliff?
Yeah,
No,
by the way, and I
plaintiffs.
don't want to use that company as the example, but do we really, does anybody in this world, in this group, think that following the 3 or 4 MSOs that no longer exist was prudent in the past? I think first of all, every state is so different, and within the state, there's unique differences that there's no one size fits all. I know it's a terrible cliche, but it's true in this situation. And I still haven't figured out a way to get around that last question in a way that the client cannot, none of us as officers of the law can knowingly allow a client to answer something dishonestly. And as their attorneys, we certainly can't let themselves commit perjury. Until you sign that document, you have not committed perjury. Once you sign that document and lie, and then if you tell the truth, there's a whole group of the industry that is skeptical and will think that it is a trap. I'm not sure that it is, but we can't. If someone said to me, Lou, could some administration in the future use this against me? I cannot say definitively, no, that cannot happen. And that gives me great pause.
yeah, and talking about the notion of a trap or the perception of it, something we haven't raised during this webinar yet are the restrictions for the DEA registered manufacturers. And I think about a legacy cultivator who's now required to put their harvested plants into a facility where the DEA has shared access to it. And it's on the record that it's yours. I can just imagine, even if we have rescheduled to Schedule 3, there's a lot of old school legacy cultivators who are just like, you want me to do what? And just in terms of the other just interesting nuances of the final rule, not just that you put them in the shared facility, but you need to sell your plants to the DEA for a nominal price and then buy them back for the same price and pay the DEA an administrative fee, which is feels
So
really weird.
The DEA is now the plug. Everybody likes that a lot. It's hilarious.
Yeah, the biggest dealer is now the United States. Yeah.
And I think this actually derives, though, right, from those conventions that we talked about earlier, the single convention, which requires that to happen. And so it feels really weird. It is weird. It results from international law. I do also want to circle back, though, to the interstate commerce question. I saw the comments. It looks like people are asking about that. And I know you did too, Dimitri. And who knows? Perhaps this is somewhat theoretical. I think the opportunity for interstate commerce requires not only rescheduling, but probably also the DEA registration to have federal authorization to move between states. And so a couple of points on interstate commerce. Note that the DEA registration, what's allowed by it is limited to what's allowed under state law. And currently states, at least to my knowledge, don't allow imports or exports. Why? Because when they wrote their law, that kind of conduct was violating a federal enforcement priority. So the final rule doesn't mean, I think, that if you get your DEA registration today, you can start shipping across state lines tomorrow, because those laws are in place. I think the Controlled Substances Act probably doesn't preempt those laws, but there's a very interesting new argument under the Dormant Commerce Clause. In general, states are not allowed to prohibit imports and exports unless they have a very good reason to do it, and the benefits to public health, safety, etc., outweigh the harms to interstate commerce. And these are pretty broad rules, and so it's been. A state has been prohibited from barring the import of waste into the state. States have been prohibited from barring the export of their water and their fish that used to be, wildlife on your state's land was the property of the state. And so presumably if those kinds of imports and exports aren't allowed, it's kind of hard to see marijuana posing a bigger threat to public health and safety than to waste and to the loss of water. So there's been a split between circuit courts over the years on dormant commerce clause's applicability to marijuana, and why? Because previously there's at least been a strong argument that interstate commerce in marijuana is federally prohibited. And if there's no federally authorized market, some courts, including the Ninth Circuit, which is the circuit in which Arizona sits, have found there's no federally authorized market. Therefore, the Dormant Commerce Clause doesn't apply. But if folks do the DEA registration route, either through this final rule or a later rule that handles the issue in, just to be clear too, this incredibly unique kind of way, there could be an authorized federal market, interstate market for marijuana, which would then undercut some of the reasoning in the Ninth Circuit's opinion in Peridot. And so if that happens, you could potentially invalidate some of the important export laws of the states, and then you could have interstate commerce market down the road, and potentially an international market too.
Yeah,
Go ahead,
John, I'll just mention that, you bring up the very salient point about the Ninth Circuit. Out in my circuit and the circuit just north of me, they went the other way. And what do we know happens when circuit courts don't disagree about the same set of issues? We have some 9 black-robed folks down in Washington, D.C. that usually like to tell us which one's right? So, I mean, I think all of this could come to a kind of a confluence very quickly. I mean, you could see there's no reason right now that there couldn't be a SCOTUS case about this next term, right?
Provided that it doesn't get struck down.
Well,
That's correct.
There you go, sir.
And
So-
one of the things before
Go ahead.
we pivot off this, unfortunately, this is only going to, because I've researched this, and to add some more nuance to it, we have 2 statutes, and we're only discussing the Controlled Substances Act. Now, that's the DEA's bailiwick. If we get into the FDA's, now we're discussing the Food, Drug, and Cosmetic Act. And so even with this rescheduling and this registering, you still have a non-FDA approved Schedule III drug. And so the states, under their police powers for health, safety, and welfare, they don't have to, this isn't garbage, this isn't water, this is drugs. And so, and not only that, it's adulterated or misbranded drugs under the CSA, the FDCA, the Food, Drug, and Cosmetic Act, Section 355 of it. So they still can't put it in interstate commerce, which is hilarious. Now, they can amend, and by they, I mean Congress can do its job at any time. Like they could completely moot this webinar right now and pass something, but they aren't going to do that. And so there's that aspect. However, now that TrueLeaf has filed all these hundreds of these registrations under this new portal that's there, do they have standing to come in and implead if and when SAM files that action and push up their legal fees? I think they might.
Lou, did you want to
I think they
comment?
do also.
Okay, now I like the fact that there's an or on that FDA or state licensed medical marijuana product, because I think that creates a lot of opportunity for entrepreneurs if this all remains in place. And that's one of the things I was thinking about in regards to brands and how they work. What do you guys, if this all remains in place, if this piece of paper remains in place, this final rule, don't you think at that point somebody can just produce in Illinois and ship it to other states and other countries?
If they amend to the Food, Drug, and Cosmetic Act to say that is not a misbranded drug, you see, like the FDA still has to do its job, and so like you can't put a non-FDA approved substance into interstate commerce, and so like the prohibition against the interstate commerce isn't coming, and it's not arising from the Controlled Substances Act. It's actually being shut down by the Food, Drug, and Cosmetics Act. So that's and so
this is the crazy, if I may, just real quick, this is the crazy thing about the way this all got done. Under normal order, if we want to use that term, there would be all the agencies would get together and they'd spend all of our tax dollars going to very expensive hotels talking about how they're going to do this and how they're going to do that, and making sure our rule 27B/6 for you Brazil guys make up with this other rule and that they all match and do everything. This is what you get with the chaos candidate, right? And sometimes you need the chaos candidate to break the dam, which is what has happened here. But then you have all of us coming back after the dam has been broken and said, well, you flooded this town and you flooded that town. and now the power plant is out. And what are we going to do about the airplanes not flying? I'm going crazy here, but I mean, this is what happens when the chaos candidate does things in the chaos candidate way. And that is exactly what happens when the president says to Joe Rogan, Joe, they're slow rolling me. And the next day, the acting attorney general just does everything that his boss wants him to do. That gets you exactly where we are and exactly these kinds of issues.
Tom's earlier point, though, at least we're having that conversation, and as critical as I might be of the president in other areas, he has in effect broken the cookie jar or whatever else you want to call it, and now it's being put back together. But it again, I believe, and I believe that as a result of creating this dialogue, it's going to demand that it be put back together, because there's just frankly too much money to be made and too much confusion. And so I think that he created the dialogue when I think everybody else was papering it over and pretending. And now I think we will solve it. But I don't think it's going to be solved through the piece of paper that was signed. It is going to be solved by what comes from that piece of paper, and which will also require synergies with the FDA legislation. And there have to be consistency. The other point, if it ever went to the Supremes, by the way, as all of us know, courts love to throw something out based on procedural defects and not have to deal with the substantive merits. This invites that.
Yeah.
So this is a really great group. You guys are awesome. I know you guys are all good people who love to help your fellow man. And I was thinking through this. I'm like giving away a lot of good free information. So if I wouldn't mind if you guys want to regroup in like 2 weeks and we could do another one and see where we're at, because I think there are going to be some changes happening soon.
Why don't we wait until a lawsuit's filed? There's going to be a lawsuit filed.
That's a very good idea.
But I want to take some of the questions from some of the comments on YouTube, so that people can have those things answered real quickly. And I want to go through those real quickly. Can anyone speak to the Washington law that, given rescheduling, would seemingly authorize the government to allow interstate compacts and transport? And I guess in regards to that, the fact that all state laws have to be changed.
They don't all have to be changed.
But if a state doesn't allow for the importation of medical marijuana, if, like, for example, in Arizona, all the medical marijuana product has to come through the license holders.
Yeah, I think almost, if I'm not mistaken, I think every state's enabling legislation requires that the cannabis sold in the state be grown and processed. I know that's certainly the case in New York, and I'm not aware of anywhere that doesn't have that. Yeah.
Right. So Washington was just proactive.
There's another tool that's available to the states that we haven't discussed, and I don't want to throw too much of a curveball, but that is, I think 35 or 37 states can sign a compact and have the capacity to make laws that would apply to them. We are now in excess of 40 states, I think, that have legalized some type of cannabis use. You might, and I don't know that any governors would be that ambitious, but they might. This is a lot of money and a lot of chaos. You might have a situation where the states will actually talk about if there's nothing coming out other than a broken system and confusion, better than broken system and confusing. There would be an opportunity for the states to say, okay, it's something that's buried in the Constitution, but they do have the capacity. I don't remember if it's 35 or 37. There's a number where they can make a compact among themselves. And given much of the legislation has been borrowed from prior states, there's a sufficient amount of consistency among the states where you probably could create a framework that everybody could agree upon. I just throw that out as another possible scenario. Unlikely, but possible if a total standstill.
And I look at this, I'm trying to look at this from the perspective of the entrepreneur, but also there's questions about patients and testing. John, do you want to say what kind of impact this has on patients real quickly?
Yeah, no, I'd love to discuss that. I think that's something that's been kind of lost in a lot of the news reports that I've seen on this issue. And that was the thing that really blew my mind. It circles back, Dimitri, to the comment that you made about FDA or. And I don't know anyone was expecting that. It's why going into rescheduling, my expectation is this would be potentially really good news for businesses with tax relief, other benefits for them. But patients would be largely left out in the cold because the Controlled Substances Act only authorizes possession if if you received it with authorization from a DEA registered dispenser. And without FDA approval, it wasn't really clear what kind of a pipeline a consumer would have to lawfully acquire medical marijuana. And of course, there's all of these consequences that patients and adult use consumers face as a result of the long-term status of marijuana, whether it's Second Amendment rights that are at least have been, and again, another circuit split going to the Supreme Court over the unauthorized use of a controlled substance. Again, medical marijuana use has been unauthorized because we haven't been receiving it from a practitioner or dispenser authorized by the FDA. And now we potentially can, if dispensaries get their DEA registrations, if this final rule sticks or another legal mechanism that's similar comes out later. And so you're looking at a wide variety of potential consequences for patients. In Arizona out here, 38%, I believe, of our land is public land, national forests, BLM, national parks, et cetera. Marijuana has been prohibited on public lands. I think there was the U.S. attorney from Montana this year talking about crackdowns that were intended there. Immigration issues, that medical marijuana consumption has been a big issue for people that want to either stay in America or immigrate to America. Public housing accessibility. Really, the list just goes on and on. Landlord-tenant law, right? Tenants sign crime-free provisions that aren't just about state law, but including federal law and specifically including controlled substances offenses. So really, it's a long list that I've been spending a lot of time going through. Also, talking about interstate commerce, how about interstate travel for patients? I think a lot of states have protections from their criminal code drug provisions for patients that get a controlled substance with authorization and qualify as an ultimate user. I should note this varies a lot from state to state. There could be also state controlled substances acts that get amended automatically or that are required by law to be amended to align with the Federal Controlled Substances Act. So this is really something that could be a subject of its own hour-and-a-half podcast, all of the different consequences for patients.
Well, we're giving you an hour and a half at the next MITA. There'll be a few hundred individuals there, a lot of employees, a lot of owners, investors, FA card holders who care about the industry and care about the patients. And so you have an hour and a half. The floor is yours. You can speak. We'll have that available for you May 27th.
Somebody asked a question in one of the comments about, and I can't find it. It was one of the early questions about the impact on on a federal job as a result of this.
Jeff, do you want to comment though as well about the impact on the patients and in general?
I would defer to John on this since he's really I think the medical cannabis patient expert. I mean, my take will be is if we get to where we're going, then it's going to look very weird for places to be able to drug test people and be like, let me drug test you for this prescription drug that your doctor prescribed for you. That's going to be a pretty whacked out position for employers to take, I would think. John, let me let you weigh in on that a little.
Yeah, I've got notes on that one. And so when it comes to federal employment, under Executive Order 12564, the use of illegal drugs is considered incompatible with federal employment. And so, again, just like Jeff said there, though, that's really, I think, the shocking thing about this from a patient perspective is we're moving much closer towards a medical marijuana card functioning like a prescription. In fact, in the final rule itself, when it discusses medical marijuana cards that authorize a dispensary to dispense to someone, the header of that subsection is actually prescription. And like someone else referenced earlier on the call, it basically just ignores, notwithstanding all of the rules that are applicable to prescriptions, this is how it's going to work for medical marijuana. Another one of these issues too, kind of regarding the shoot from the hip and ask questions later, and you've all these different state laws that are not, and it's not like a uniform thing we have, like the Uniform Commercial Code. We all have different state laws. And so just from an Arizona perspective on this, on patients, I should note too, for patient perspective, this is not automatic. This is if you get it from a DEA registered person in compliance with the final rule, not just any medical marijuana for a patient, because it's about how you get it. But for our medical marijuana cards, as it stands now, we have no reference to which practitioner recommended the card. but that's now one of the requirements in the final rule for a card to be effective. It needs to list the practitioner. And so that kind of circles back to, I think, to your point, Dimitri, about changing state laws. I wonder too, our medical marijuana law here has very, very, very stringent confidentiality provisions that are, I think, in large part intended to prevent the disclosure of that information to federal authorities. And so I wonder here too about if there's going to be a requirement for regulators to work more closely to federal and state level, and how that would function in a state like Arizona where there is such confidentiality. So a lot of questions, but yes, very salient for federal employees, in addition to many employees of federal contractors whose contracts required drug-free policies at the workplace. So again, the list just goes on and on. I'm looking forward to
What
the
about
hour and a half of meetup.
the CDL truckers?
I was going to say that.
Yeah, there's millions of them.
Yeah. Mm-hmm. I don't have an immediate answer on that one. I wouldn't be surprised if there's changes there, but I haven't confirmed it.
Wow. So, this is incredibly tough for attorneys because you guys want to give your clients absolute answers, and there aren't any absolute answers on this particular subject.
There are.
I don't know, 43 years. I don't know that I've told many clients I gave them an absolute answer.
Lou, I give them this one. I'm insured.
No, but
And by the way, if anybody has written opinion letters, and I have, the thing about the opinion letter is really good until you read the last 3 paragraphs. And then you realize that the prior 3 pages have minimal value.
so
We're still, Dimitri, we're in the wild, wild west. We're still in the wild, wild west.
right.
There are some new rules by the sheriff, but you're still in the wild, wild west.
But along the last 16 years that 14 years I've been involved in cannabis, it seems the best option is just do it and deal with the results, because the momentum is on the side of not being thrown in jail. Because as an entrepreneur, technically anybody can be thrown in federal jail right now, except for the Cole memorandum. And so along those lines, you guys can't really advise your clients, take chances. What the heck? It's Schedule 3. Make some medical marijuana product and start doing what you want. You see what I'm saying? Is that?
Dimitri,
I mean, I
I
think
don't
that-
know, bud.
Yeah, I was going to say, I think that arguably cuts both ways, right? The federal government was saying for years, like, don't do anything involving marijuana, and people definitively didn't do that, and it worked out. Somewhat on this subject, too, I think it's worth mentioning the Rohrabacher-Farr Amendment. There's been this rider to prohibit the use of federal dollars for enforcement, prosecution of state-compliant medical marijuana conduct. And so my understanding is that's still in effect. And so it's one of the other questions I've been puzzling over is, like, is this you need to do it, or how optional is it in light of the amendment, but also the command in the final rule that people must register? So
Yeah, will you
there's
be
a little bit of attention
putting
there.
yourself at a market disadvantage by not registering? Not necessarily trying to take advantage of the opportunity. Are you putting yourself behind something that's actually a gift that the federal government has thrown out? And along those lines, I was thinking to myself, you should always maintain compliance with state law, no matter what, because they're much closer to you. But what do you guys think about that? I mean, could you be missing a gift?
You don't have to take the gift right now. The gift's open
I
for
don't want
about
to be
2
the first in
months.
line taking that gift, man. I don't. Let somebody else, let them have the gift first and see exactly how that works out.
One of my questions when it comes to implementation is how siloed the DEA registered ecosystem will be. Will they require all marijuana sold in DEA registered dispensaries to originate, and perhaps not now because it's impossible today, nothing was DEA registered a few months ago, but moving forward prospectively, will they require DEA registered dispensaries to sell marijuana from DEA registered manufacturers, and kind of separate the supply chain to require it to all be registered? In which case there could be some pressure, market pressures, for if a significant enough number of people get DEA registered and the DEA requires stuff to move through its registered ecosystem, maybe you see some market pressure at that point, that folks feel like to not lose out on all of the demand from DEA registered dispensaries that they feel pressure to get registered to? I don't know. It depends, I think, on some questions we don't have high confidence answers to, at least yet.
If anybody needs my name to be on one of those DEA registries, I can always host this podcast from Brazil.
Yeah.
Extradition. Well, look, there's lots to talk about, and I want to regroup with you guys in a couple weeks, or as you guys determine is the next best time. People can reach out to
Tom's
you.
point about waiting to the suits filed makes a lot of sense, because we're gonna probably have we're gonna have uncertainty after the suit's filed, but it'll be certain uncertainty as opposed to uncertain uncertainty now. I'd like
Yeah.
to see what it looks like.
Well, I know you guys have lots of clients. You guys meet a lot of people and talk to a lot of people, and I would encourage anyone who's listening to this or anyone who meets you guys to utilize you as attorneys, not just because you have fine minds, but you're all very nice people, all four of you. How do people get in touch with you?
Best way for me, shoot me an email, John, Jon without the H, at fullspectrumlawcollective.com.
And then,
Lou,
John, everybody prepare some closing thoughts as we go through the contact information. So, John, get ready your closing thoughts. But Lou, go ahead next. Contact info.
Lou at lnmlaws.com. Lou at lnmlaws.com. I was once MAGA Laws, but then found that I could not do that, even though I was MAGA before he was MAGA. So I am now my initials.
Tom?
Yeah, you can find me over at Cannabis Legalization News on YouTube, or my website for my legal practice for cannabis is not my regular one because you get blacklisted. Wonder if that'll change now that it's Schedule 3. But that's cannabisindustrylawyer.com. You can go there and get in touch with me.
Yes. And Jeff?
Get me at 420jurist.com. You can also find me on LinkedIn, Jeffrey Hoffman. I'm probably the only cannabis attorney named Jeffrey Hoffman on LinkedIn.
Okay, excellent. So we'll now give like a minute for each of you guys to do some closing thoughts. We'll do John, and then Tom, and then Jeff, and then Lou. So John, go ahead. You're on mute, John.
Thanks for that, Dimitri. Just kind of wow, it's just the extent to which this was surprising. I think one of my high level thoughts again is just what a victory for common sense after all of these years. It's been over 4,000 years now since people have recommended to others they consume marijuana for a medical purpose, starting in China, onto India, also about 3,500 years ago, and so many states that have authorized the medical use of marijuana. All of the people in America who have firsthand experiences with the medical benefits, myself included. So just gotta love to see the victory for common sense and acknowledging what so many of us know is true. Fingers crossed that it sticks. Again, if it is, I think one of the main messages here, if you're not in the business space, and if you are and you qualify, is get your medical marijuana card. There's a whole bunch of good reasons to do it now, even if you have kind of skipped in the years since adult use. So I look forward to attending more of these webinars, discussing more what this means as the final rule rolls out, as the potential challenge and likely challenge proceeds. So thanks for having me. It's been a great time discussing this with everyone.
Tom?
Well, many lawyers practice in what they call well-settled areas of the law, whether it's torts or criminal law or other stuff like that. This is novel law. This is not well-settled at all. This is brand new, making it up by the seat of their pants. And so the lawyers that have too much confidence, this is something that Learned Hand said. He was a judge once. Great name for a judge. But for the people that are cocksure about anything, the sky has ominous tones or something like that. Be wary of lawyers that you meet that are too overconfident and not nuanced enough when giving you and your company advice on these brand new legal issues that didn't exist a few days ago.
Jeff?
Yeah, I think that's sound advice on Tom's part. I echo what John said. Cannabis has been part of humanity as long as there's been humanity. It's wonderful that we're finally getting some sanity related to the medical side of things. I'm really excited that we're going to be hopefully able to start seeing real clinical trials and real funding go into figuring out what is the good, bad, and the ugly. I am a believer that there are absolutely great uses for cannabis in a medical setting. I am not one of these people that believe cannabis is the cure-all for every medical ailment that every person has. So I do think it will be wonderful for us to get the science about what this incredible plant does for people. And also, let's be real, what it doesn't do. That being said, I am not optimistic about what this portends for what is called recreational, or here in New York, we call adult use cannabis. I do, in fact, see a putative scenario where this is the first nail in the coffin for recreational and adult use cannabis in the United States. I'm very concerned about that. Dimitri, and you and I have talked about that a little bit on your podcast, some of the events we've been at. And I just think we have to be very careful about what's going to happen here. I'm not optimistic about what this administration is going to do in these upcoming hearings, assuming they happen, related to recreational or adult use cannabis. We know the president himself is not a fan of it. Everything that he's talked about here has been exclusively related to medicinal use. So I just think people that are in the adult use or recreational space need to really be very careful what they wish for here. I do think there are outcomes which are not good for that part of the industry.
And Lou, go ahead. And folks, none of this, our sponsors up there, none of this is possible without Lou's law firm and Moon Rocks, a nice brand that's spreading out of California, sponsoring these kind of things. So we thank you again. Lou, closing thoughts from you?
Happy to do it with this great group. Let me disagree harshly with Brother Hoffman. I think ultimately, I just looked up, Gallup in 2023 said grassroots support for legalizing marijuana hits record 70%. And what's interesting, when you look at 1969, it was about 10%. And I believe that the will of people will ultimately prevail. I think, like everything else, though, there will be bumps in the road, there will be hiccups, whatever word you want to use. There will not be a direct line. But I think that if over time, and I believe there will be a default to medicinal, because I think there's even greater support, probably around 80 or 85% when you couch it in those terms. But ultimately, I believe that this executive order will be the beginning of something good for the industry, because it's created a dialogue, and it will create, because of the confusion, will by necessity require a reasonable and consistent nationally applied standard. Now, that may be going back from where some places like New York and New Jersey may be, but as a national standard, it creates an opportunity, I think, that will ultimately be positive. Now, I am 68 years old. I've been practicing law for 43 years. I am not sure that I will see that ultimate result while I'm still practicing, but I am confident it'll happen. And I think within the next 5 to 10 years, not immediately, but I think over that arc, I think then we will, and the real problem will happen then is all the big companies are going to want to come in and dive in on this industry. But that's a whole nother discussion. Thank you for the opportunity, Dimitri.
Well, excellent. And I'm sure you're reaching out to your friend Senator Booker and seeing how he can get involved.
We moved him. If you were at the Ignited conference we had in Washington, he spoke publicly and unequivocally about his support for this industry, and I think that was an important voice.
Yeah, I do want to recognize that Senator Booker, Senator Gallego, they're champions on this issue. So people should reach out to their offices with information and concerns, and let them know kind of what's going on, the struggles of industry, of operators, of patients, etc., because they do care. So I'd like to recognize that. But again, I thank you guys for your time. It is an honor sitting amongst you. It's one of my great honors of my tenure in the cannabis industry, sitting amongst all these fine CPUs. So anyways, this has been another episode of Meet Unshackled. And thank you again to our sponsors. And we will circle back. So stay subscribed to our email list. And if you want to meet John, I know, John, you will be there May 27th, hosting a panel of attorneys discussing this issue as it relates to.
If anybody's going to be in Atlantic City next week at MJ Unpacked, we have a booth and we have a couple of receptions, and Would love to see folks and sponsoring the official after party, 9 to midnight at the Showboat Pool.
Excellent, excellent. Yep, so you can physically find Lou in Atlantic City next week at MJ Unpacked. That's fantastic. And any you guys gonna pop up anywhere, Tom or Jeff, anytime soon?
I got to get my dispensary open, and then I'm out of here in the last week of this month. After I get the dispensary open, hopefully I can resurface for a breath or two.
And Jeff, will you be at Revelry?
I'm not sure yet, but I will definitely be at the New York State Cannabis Control Board meeting, which is a week from yesterday out in Nassau County.
Well, these are exciting times, and you guys are great people to have on your team if you're a business or an operator. So I'd highly recommend all four of you. Again, thank you for your time, and we will see you next time. Are we stopped?